and I'm sure Liz would agree with me that I can't think of anything here lately that's caused us more grief, and that is a party not being able to close on time. And what do you do? And how, the impact on the buyer. And so I thought we'd talk about that. I don't think I'm going to be able to do a primer. I've done an outline, as you can see, but I don't think I'm going to be able to do a primer for this one. It really doesn't lend itself well. It's a little bit complicated, but I will I'll give some thought to that after the class. And as before, I've got the chat box open, so you guys can either send a question by chat, or maybe we can just handle it. Pop your audio on as we get to the end. So the first thing, in terms of getting to talk about settlement dates, I want to talk about a material versus a non-material breach. And so obviously material, big, important; non-material, not so big, not so important. And the law really looks at that in terms of a party breaching the contract. Kind of a classic example that I always give is that, a builder agrees to build a house and it's $1 million, and you get to the closing and there's, a nail has popped in the sheetrock, and the buyer stomps his foot and says, well, I'm not closing. Well, that's not a material breach. It's $1 million. It's a sheetrock pop. And so we would say that one's a non-material breach. And to contrast that with a different kind of situation, I mean, you can imagine the house is struck by lightning, setting aside risk of loss and all of that. The seller's obligated to deliver in all the contracts the property, the house, in substantially the same condition, and it burns down or lightning strike. Well, a buyer is that's material. And so the buyer would be justified in refusing to perform. And in reality, so the way lawyers, in terms of a general categorization, we say there are material breaches, and those are breaches that are significant enough on a provision that's material to the essence of the deal that would justify the non-breaching party from performing. And in essence, you can walk away and hold the other side in breach and sue them. A non-material breach, on the other hand, you don't have the right to do that. You may have the right to compensation for the value or the loss of the occasion by the non-material breach, but you don't have a right to say, I'm not going to close, and to use our real estate closing situation. And so we'll jump a bit to time of performance, closing dates, settlement dates. And as a general proposition, the law looks at a settlement date, the time of performance, as not being a material provision. And in the real estate context, going back centuries, really, if you thought about it, at least back then and through a good part of history, if somebody was buying 100 acres, life then was not the way life is now. And it didn't so much matter whether that closed on a Tuesday or a Wednesday or a Thursday. What was really important and material to the transaction was the 100 acres, the amount being paid, the state of title, those kinds of things. But whether you closed a day here or a day there, it wasn't exactly material. So you always had a date in a contract, but if one party wasn't able to perform on that date, the law wouldn't say that there's been a material breach so as to justify the other party walking away or not performing. So that's kind of the general rule and background. And now we throw in the phrase that all of you have heard, the magic words, time is of the essence. And so where judges over a long period of time have kind of come to the conclusion that as a general proposition, the time or date of performance isn't material, the parties are certainly free to make it so. And that can be done in a couple of ways, but one by conduct or by other provisions. But the most significant and clearest way is to say exactly that. And so the words time is of the essence have sort of developed as a term of art, or a phrase of art, I guess I should say, where the parties are signifying we are making the time of or date of performance as a material provision in the contract. And so that would result in, if you said settlement on, March 31st, time is of the essence. Now you get to March 31st, and if one party is unable to perform, that party is a material breach of the contract, which would justify the other side from refusing to perform. If you don't have that, then the law is basically going to look at it and say, well, it may still be a breach. One party may not have done what they promised to do, but that doesn't justify the other side saying we're walking away from the deal and suing you. You still are going to end up having to close, but you may be able to recover delay damages. As always, the exact language of the contract is important. And so I went ahead and summarized, took snippets out from each of the contracts, and have listed them here. So the first, of course, is the rain contract. And again, I've just taken snippets. It's not verbatim. So the rain contract says settlement to be on or before, and then you insert a date. And as you probably know, the rain contract goes on to have language that says that date can be extended for a couple of reasons, and that's limited to loan or repairs. I mean, not repairs. I'm sorry, it's loan or title work. Strike that. Repairs is not included. I'll tell you why I had that on my brain when I wrote this. But those are the only reasons. And then the rain contract goes on to say that, if a party isn't able to close on the specified date and it's not a loan, a financing, or a title issue, then the other party has the right to terminate. It expressly says that. So I think, again, time is of the essence are magic words, but the law supports the idea that it doesn't have to exactly have the magic words. And so I believe, and I think most local attorneys do as well, that the rain contract on the settlement date is basically time is of the essence, except for the two situations where, there's a grace period, I guess, for lack of a better word. The reason I accidentally wrote repairs here and not title is because what we often see, and that's why I had it on my brain at the time, is that the repairs aren't done by the settlement date. Well, that's not one of the reasons under the rain contract that you can extend the settlement date. So if the seller doesn't have the repairs done by the date specified, the seller's really in breach, and it's that clear cut, and the buyer's going to have a right to terminate. The VR contract, in my view, in this regard, is really the worst of all worlds. It just says settlement is on or about. Well, that clearly makes it not of the essence. And even worse, the or about, well, does that mean Wednesday on the 30th? Or maybe it could go Friday or the following Monday? Well, it's just on or about. So the VR contract really is gray as far as the closing date. And we're always hard pressed to pin somebody on their heels when we're dealing with a VR contract. And of course, one of the problems we frequently have with a VR contract is there's another clause in that contract that gives the seller the 60 days to fix a title problem. So you may have an unreleased deed of trust, and the seller says, okay, well, I can get it fixed, and I'll get it fixed. It's just going to take time. And we're going to go past the specified closing date, and I can do that for up to 60 days. To sort of interrupt, going through those four for the moment, what I find odd about all of this is, literally this law, particularly with respect to real estate's kind of special in the law in a number of different ways. And so this idea, the 100 acres, the old farm closes Monday, Tuesday, or Wednesday, it's not that. But that's not, as you guys know, that's not modern practice. Modern practice is that date is important and people rely on it. Buyers have movers scheduled. We have rate locks that expire. Sellers may be closing on another house. And so this old sort of, in my view, antiquated idea that the time of performance in a real estate contract just isn't exactly that important or that material. That's certainly not the way everybody looks at it, including parties who are buying and selling houses. So, for that reason, I think the VR contract is really, in my view, behind the times with this on or about. We could do with a lot more specificity, maybe the way the RAIN contract does it. And the CVR contract comes pretty close. I mean, it has the on or before. At least that's not on or about like the VR contract. And then it goes on to have, those of you in Richmond know this, it's got a couple of choices to specify what happens and whether or not it can be extended if a party's trying very hard. Those aren't the words. In other words, trying to get it closed, or the other block that can be checked is giving the party the right to terminate, like it does once you go past it. I thought I would look, this has been this way for a while. Interestingly, the NAVR, now NVR contract does have time is of the essence. It doesn't say that in the settlement clause. It just has a general clause that says time is of the essence on the date and time frame specified in the contract. So to my knowledge, NVR is the only association contract that handles it and tries to make it time is of the essence. So where does that kind of leave us? Okay, so yeah, the contracts, at least a couple of them anyways, say give the buyer a right to terminate if the seller doesn't close on time. That's not really, we know that's not what the buyers typically want. They want me or Tanya or Liz or somebody to go punch them in the face and make them close. I mean, that's what they want. They want it closed on that date. And again, they may have, given notice on their apartment lease and they got to move out and they got movers and don't have anybody to take care of the kids, no place to leave. I mean, and it's terrible. I'm not, it's bad. I'm not making light of that whatsoever. And of course, sellers can be in the same sort of jam if, buyers aren't closing on time. So there isn't a great solution to this. I wish there was. You see the language in the contracts. I think by now you guys understand what that means. Yeah, somebody might have a right to terminate, but they really don't want to terminate. Here's sort of the thing that doesn't really work out practically. If we go back to the idea of material or non-material breach, remember I said a material breach is where the non-breaching party has a right to terminate and then sue for damages. Well, even on a non-material breach, you still have the ability to sue for damages. So on some of these contractual clauses, the party that didn't delay the closing may well be able to recover some delay damages, at least in theory anyways. You'll get pushback. We'll always get pushback if we assert that. The other parties will almost never agree to pay it. They'll just say, well, time isn't of the essence. But that's not really the law. That goes to material versus non-material, not as to whether there might be damages available. But as a practical matter, you got to go through mediation. I mean, the other party just says no. And then what are you going to do? And refuses to close if you're going to insist on collecting damages on the CD. So what are you going to, go through mediation and then spend how much in attorney's fees to try and collect, $500 or something. So as a practical matter, while in theory there may be some delayed damages available, we just try and work through it without going down that road because, again, it usually doesn't pay off, and our efforts are usually better spent in just trying to get the thing closed. But they are potentially and theoretically available. I wanted you to know that. Should you write time is of the essence? No, please don't do that. There may be situations where it's merited. A 1031 exchange, for example, may have serious deadlines and serious consequences, based on the IRS, the tax code time periods involved. And you could conceivably have a situation where, it not closing in a timely fashion, the consequences are such that we might consider amending the basic contract to make it time is of the essence and specify damages. But don't write that thinking that it'll help protect your client to make sure the other side closes on time. Well, it would do that, but on the other hand, that sword cuts both ways. And my experience, and I'm sure yours has been, pretty much everybody tries as hard as they can, pretty much, to close on the date. And quite often it just can't close on that date for reasons beyond a party's control, whether it's lender or title company or just, things happen. But the problem would be is if you write time is of the essence, you've made it clear that somebody's in breach if they don't close on that date. And that person could well be your client. From the title company standpoint, I really don't even want to do time is of the essence closing because the risks are just too great. We can't charge to accommodate that risk that maybe it doesn't close for some reason attributable to us. So yes, there might be situations where you want to do that, but you got to be very careful about it. And I would prefer that you reach out to me or Liz or Danya. Danya, that's my new word for Tanya, Don. I just say Danya or Sandra. So that's really all I have. Unfortunately.
Can I add one thing, Brian, before you close?
Yeah, sure.
So I think one of the other things that seems to come up a lot when it relates to closing dates, and you mentioned it, is the buyer's lock. And so obviously we're in a market right now where buyers have no leverage, no voice. But when we get into a little bit more of a balanced market, I do think it's not a bad thought if you have a buyer whose lock is expiring right at closing to address that in the contract, that the seller will be responsible for amending the lock if the loan doesn't close or if the contract doesn't close for reasons on the seller's side. Can't really do it in this market, but at least you're thinking about it.
Well, yeah, I mean, I think the market would really have to swap the other way, because if a seller came to me and said, "Hey, what do you think about this provision?" I'd say, "No way." It's hard to understand the risk. Maybe if there was a specific amount attached to it. But the one thing that I've never really seen done in the residential market, anyways, are liquidated or penalties for not closing on time. And I'd be concerned about going down that road, particularly talking about your example. Rates could jump significantly for all we know. And I'm not sure a seller or a listing agent should ever agree to take that risk. The market would really have to switch the other way before sellers would want to do that. I think, but that I don't know that I gave a lot of hope about solving this kind of problem. But the one thing I think that always should be done is managing expectations of the parties, your clients, and giving some leeway. I mean, so if you're representing a buyer, for example, and they're getting ready to, give notice on their apartment lease and schedule their movers, I think you just have to have a conversation with them about that. It's not unusual for a closing, for reasons beyond anyone's control, that it doesn't close on the appointed date. And those buyers who just have zero margin to accommodate that kind of slippage on the date, I think that's a mistake. Everybody's trying to save money, and there's nothing wrong with that, but not giving yourself some leeway and as an agent advising them about that, I think, that could help a great deal. And of course, the same is going to be true for the seller. Managing the expectations, approaching it as though it's not unusual and that it happens, and be prepared in case it does happen. And, then in terms of the rate lock, which is obviously a problem, is, the buyer needs to discuss that with the lender and find out what the options are and how much it would cost and that kind of thing. So I think, it's worse when it's always bad, but it's worse when it comes up 2 days before everything's scheduled to happen. And now there's no, you didn't ever told me that could happen, that kind of thing. So it's not your fault, but I think that we could probably all do a little bit better job of managing the expectations of the parties. So anybody else have anything? Well, I thought there'd probably be lots of questions on this, but in any event, I do appreciate you guys tuning in, and I'll see you next Thursday. Y'all have a great day.